You are Amy Susan Hewitt. Ms. Hewitt, you understand why we're here today?
Yes, and I would like to get a GAL or a PASA advocate for my case and request that before making any determination, the court review his criminal record, request a record of any child protective investigations, and that he's been involved with, and require he take a drug screen.
Well, first and foremost, let me tell you that there's a motion that has been filed to set visitation, and that motion was set for hearing today. You have not yet filed any sort of response to that motion as far as this record reflects. Have you filed anything in writing?
I don't have an attorney.
Yes, ma'am, I understand that. The child support DA is not going to represent you in this matter because that's not their job. They only handle the child support action. But you have the right to hire an attorney of your own choosing if you choose to do so. The question is whether or not you are planning to do that.
I can't afford it, so I'm told to ask for guardian ad litem.
A guardian ad litem.
Oh, sorry.
Guardian ad litems are not automatically awarded because of the simple fact that if I appoint a guardian ad litem, there has to be, number one, a valid basis for the appointment of a guardian ad litem. Number two, it has to do with who is going to pay for the guardian ad litem's fees. They don't do it for free. Usually there's an attorney that's appointed, and that attorney expects to be paid according to that. And in a civil case, most of the time the guardian ad litem is paid by either one or both of the parties. So it would be an expense to you and to Mr. Fenton. So paternity was just established in May of this year. According to the file, it says that on May 20th of 2024, the court held that the father was the biological father of the minor child. Well, I cannot, simply because you asked me to appoint a guardian ad litem. Now, as far as the CASA, you have every right if that's what you choose to do, but that is not something that the court normally orders as well. You have opposition to Mr. Fenton having visitation with a minor child?
He's 3 years old. I let him come around supervised a couple times. Over, and he lives out of state.
Well, here's what we're going to do. We're going to conduct a hearing of sorts, and I'm going to hear from him about what he's asking me to do, and because he set this motion, and then I'll hear from you about what your reasons are. What you're stating is really testimony, and I need that to be under oath. So we'll have this hearing, and then when I've had the hearing, I'll make a decision on what, if any, visitation or whether to appoint a guardian ad litem at that point, okay? All right, just have a seat at that table, please. All right, Mr. Murphy, you wish to put on proof?
Yes, Your Honor. We would call our client, Matthew Fenton, to
Mr.
stand.
Fenton, step around, please, and have a seat in the witness stand. So.
Could you please state and spell your full name for the record?
Matthew Christopher Fenton, MATTHEWFENTON.
And Mr. Fenton, are you the co-parent? Are you a co-parent of Amy Susan Hewitt?
Yes, sir.
Both of you have a child together?
Yes, sir.
How old is the child?
He turned 3 February 28th.
And you're here today because you would like to begin visitation with the child. Is that correct?
Yes, sir.
Okay. Have you made any?
You're going to have to speak into that microphone a little bit more.
Yes, sir.
Have you made any efforts thus far to get visitation?
Yes. She allowed me to come on 3 visits.
Who is she?
Miss Hewitt allowed me to come 3 different times after March 25th when I was, I'd taken a DNA test, and I went to her house. after 12 noon, and I stayed until 7 two times, and then the third time I stayed until 9 p.m. My mom, that's just turned 82 years old, she went twice. That's the only 2 times she's ever seen him. And we just would like rights. I was never told the truth. I was told that it was another man's child, that she had DNA tested the father. I came in when he was born, or when his expected date was February 24th, 2021. I was working in Virginia, and I drove in from out of state, 8 hours away, and Miss Hewitt told me that it was not my child, that she had DNA tested the father, that it had nothing to do with me. I never heard anything back, and I don't know. I believed her. I've never had a child before. This is my only child, and I'd just like to, be involved in his life and get to visit him.
Has Miss Hewitt refused you visitation at any point?
Yes, sir.
Tell us about that.
I went 3 times. Well, we had the court hearing, and it said on the documents that you have there, Mr. Wolf signed off that I should receive reasonable visitation. And I highlighted it and sent a copy to Miss Hewitt and asked her for visitation. I even really wanted to get him for Father's Day, because I'd already missed a few. And I drove down and went to the district attorney's office that day and spoke with the child support lady as well. And, she told me to contact my attorney, and then I came on to the courthouse. But yeah, she will not allow me to see him, and told me not to come back to her house. And that pretty much happened when I filed for visitation rights.
Did you advise her that was part of the court order?
Yes, sir.
Looks like alternate residential parent, non-custodial parents will have reasonable visitation privileges. Did you tell her about that?
Yes, sir.
What was her response?
She doesn't care.
And you did give her a copy of that?
Yes, sir.
Okay. You just heard her make some claims just now when she appeared up here at the podium about criminal charges and all sorts of other things. Do you have any kind of response to that?
Yeah, I don't have a criminal record. I've worked on federal projects for the last 23 years since I was 18. I'm currently doing a Send Elements battery recycling facility, which is government backed and is a federal project. I take random drug tests, and more than happy to take one right now today in court. And I don't even have a bad driving record. Nothing's on that as well. So.
Where do you live at?
I live in Scottsville, Kentucky for the last 16 years. It'll be 17 years in April of next year.
Okay. So just from a, just so we understand how this would work, how would you propose, visitation work if you being out in Kentucky and her being here in Tennessee?
I'm more than happy to make the drive to come pick my son up and drop him back off. Just whatever it takes to see my son.
You just want to start seeing your son again?
Yes, sir.
Okay. Let me ask you this. Have you taken a parenting class recently?
Yes, sir. I have a completion, but it's on my phone. I don't have it printed off. But
You don't have a physical copy, but you did complete it?
Yes, sir. And
This morning?
I emailed it to you as well. So we can get that,
So you'd be happy to late file it if we have to?
Yes, sir.
Okay. All right. Those were all my questions. Thank you very much, Mr. Fenton.
Hewitt, you are representing yourself at this hearing. You have the right to ask questions of this witness. I'm going to give you a chance to testify if you want to testify, but do you have questions that you want to ask of this witness? You're not required to ask questions. I'm just giving you the opportunity. If you want to ask questions, they must be in question form, and it must relate to some issue that's before the court. Do you want to ask him any questions about what he's testified to?
I gave you time with Ashton supervised at my house, right?
I took him every time that I was there, and your daughter.
And supervised you with your mom?
No, I mean, the first time wasn't. My mom wasn't with me.
You just testified your mom came with you?
Twice.
Yeah.
The one
And
time, the first time I came alone, and I took them to the auto parts store to get parts to fix your car because it was broken down. And I came back on my first visit and fixed it so you had transportation. And then also gave her money to get insurance and to get her tags for her vehicle so they would have a reliable vehicle and transportation.
I never denied you that seeing him at my house supervised, right?
Yeah,
I denied you.
the messages I have say not to come
I've got
back.
all of them printed out, along from your ex-wife, too,
Okay, I mean, I don't,
where
you shouldn't have, I don't see,
the reason is he's autistic, nonverbal. You've known about him since day one.
Number one, you're testifying now. I'm going to give you a chance to
Sorry.
testify, but you are not required, I mean, you cannot make statements and testify at this point.
Well, CPS has been involved with him in the past and his ex-wife.
And again, you're testifying, and I'm not going to
I'm
allow you to
sorry,
do
okay.
that until you take the stand, okay?
Okay.
All right, thank you. Step down. Oh, let me ask you a couple of questions.
yes, sir.
You're asking for visitation at this point, but in the petition that you filed, you asked to be made the primary residential parent for this child. You aware of that?
Sir,
In other words, you want to be the person who has full custody of the child and she has visitation,
yes, sir.
even though you've not had but 3 visits with this child since he's been born?
Well, I mean, I'd like to make up for lost time and at least have, split visitation with him where, I mean, he's taken to me very well. I mean,
No, she's made statements several times about this child having some special needs. Are you aware of any special needs that your son has?
yeah, he's nonverbal. He doesn't speak, but I'm able to teach him stuff pretty easy.
And he's 3 years old.
Yes,
Okay.
sir.
All right. Anything further, Mr. Murphy? Thank you, sir. Step down. Mr. Murphy, you may call your next witness. All right. Ms. Hewitt, you want to tell me why you don't want to let him have visitation, then come up, raise your right hand, let's place you under oath.
He has a bad history, and I've got proof from his sister, his ex-wife.
Well, number one, let me explain to you, this is a court of law. That means you can't just get up and say you've talked to somebody and they've told you things. You have to have those people come in as witnesses and testify themselves of their own direct knowledge. Otherwise, what they say would be considered to be hearsay. In other words, we could have witnesses come in all day long and say, well, Joe Blow out here told me that the father is a terrible human being and he does this or does that. So it's not sufficient for you to bring in statements of other people who supposedly have knowledge. You would have to have some sort of testimony from them in person so that Mr. Murphy, representing your child's father, would have their opportunity to then cross-examine them to determine whether or not they're being truthful or not truthful. That's the way the system works. So.
Get in they're sealed court documents, but his ex told me she would resend them to me.
Again, Mr. Murphy's objecting to you saying what
So I
his
would need
ex-wife...
her,
When I'm talking to you, just be quiet, okay?
sorry.
When Mr. Murphy is objecting to you saying what the ex-wife said, which is the very reason that I've explained to you, that it's considered to be hearsay, a statement by someone made outside of the court that you're bringing in to prove the truth of what's in that statement. That's classic hearsay and it's not admitted. So tell me, other than what someone told you, what knowledge do you have? First of all, what kind of relationship did you and Mr. Fenton have before you became pregnant?
I was best friends with his sister, and we grew up together.
Okay.
I love his mom, love his sister. They had warned me prior, but
How long did you and Mr. Fenton have a relationship?
it was 3 months and he started acting erratic.
When you say, if you saw something that he was doing erratically, tell me what you saw that you think was erratic.
Driving crazy, screaming, scaring me and my daughter, cussing, throwing things.
And why were those things happening?
Be honest, I don't know.
Were you and he having an argument?
Not at all.
Was he under the influence of some substance? You have any knowledge of that, or are you just assuming that?
I have knowledge from being around past family members with the same issues and talking to his sister and mother and them informing me, you know.
Again, Mr. Murphy is
sorry.
objecting, so I'm sustaining his objection. I won't allow you to testify about what they said. So you become pregnant, did that end your relationship, or did you stay together after you became pregnant?
I've got my messages in his, but he didn't want us to, he just dropped off the earth because I wouldn't uproot my children and go live in a travel trailer while he worked out of state.
So when did you and he stop having a relationship?
I was 4 months pregnant.
All right. From 4 months pregnant until March of this year, did he ever see or have any contact with this child?
No,
Okay. Did you ever refuse him to have contact
No.
with the again, just wait till I'm finished. Did you ever refuse to let him have contact with your son before that March date that he's referred to?
no, sir.
Did he ever contact you before he was served with a petition to establish paternity and to set child support? Did he ever contact you and ask for visitation?
No, sir.
All right, so the first time he asked for visitation was after you and he had been to court over the child support?
Yeah, it's
Oh.
about,
And then you allowed him to have supervised visitation, come into your house, being with your child, correct?
yes, and his
All
mother.
right. And his mother came along too?
Yes.
Is there any reason why you would not allow him to have that type of visitation right now?
I never said that I told him he could come to my house
All right.
supervised.
Tell me about your son. What issues does your son have?
He's got a rare heart condition, Epstein's anomaly, pulmonary hypertension. And then he's nonverbal autistic. He gets therapy through the week and PK3
Where does he get therapy?
at pre-K with special services. He's started at TEIS, Tennessee Early Intervention,
Okay.
from birth, and then we moved over with the Board of Education when he turned 3. And he goes to school during the week, and he gets OT, PT, speech, ABA.
All right. And where does he go to school?
Oakmont.
Oakmont. Now, what I'm understanding you to say is that you have concerns on what people have told you about Mr. Fenton and his past, but that you would be willing to let him have visitation at your home?
I would be willing to let him, if I was there, just not
Well, that's what
him
I'm
take.
talking
Yes,
about.
sir.
But you don't want him taking the child away at this point?
No, sir.
All right. Anything else you want to tell me about, other than what somebody may have told you? Is there anything else you want to tell me about your son?
He's
Mr.
my
Fenton.
world.
You understand that when he was held to be the father by the child support magistrate, then that means he has certain rights under the law, that he has a right as a father to see this child, his son. The only question, you don't get to have it both ways. You don't get to have, for example, the child support paid but no visitation, absent a finding that he poses an immediate and serious harm, threat of harm to your son. In other words, if you establish paternity, those rights go with the child support obligation. He has a right to see the child. So the question is, do you understand he has a right as a father to visit with his son?
Yes, and I never denied him seeing him.
Okay.
And I've raised a 22-year-old with autism who's in college, successful, works at Walgreens as a pharmacy tech. I've got a 12-year-old with autism also, like, I've done this a long time, and I've known him a long time, and he wouldn't be safe.
But, Mr. Murphy, you have any questions? Lost our camera. Goodness sake. Drop my pen.
Daniel Murphy. Let me ask you some questions. First off, I think you made it pretty clear. You said you're not opposed to him having visitation with the child. Is that correct?
I never was, as long as it was supervised, I was there.
Okay, what exactly are your concerns as far as him being able to have the child at his house?
Number one, he's never raised a child or been in his life for 3 years. He doesn't know him. I mean, just because he puts his hands up to him, he does it to any man because he's not around men.
So how much time would you say would be needed to get to know the child before you'd be comfortable at that stage?
With him, what stage?
With him actually having a child at his house?
I don't know.
You don't know.
I mean, he's autistic and nonverbal, and I mean, he's a complete stranger.
Have you given Mr. Fenton the opportunity to assist with the child's autistic and nonverbal needs?
I was more than willing. The only reason I objected to anything was when he told me to have him ready Friday night, and then he would drop him back off on Monday. That's when I cut it off.
What do you mean that's when you cut it off?
That's when I cut off. I was like, you're not taking my child out of state that can't even tell me when something's wrong. You've never raised a child. You have no idea what this is like, much less with autism and his heart condition. He's never been a night away from me.
Okay, but I think, is there a point to where you have to understand he has parenting rights to this child just like you do, right?
Yes.
So is there a point to where you'd be willing to agree, okay, yeah, you can take him overnight?
I mean, we would have to see if it would, I don't know.
Okay. Judge, let me see if my client has any questions other than that.
All right, thank you, ma'am. You may step down and have a seat at the table. Mr. Murphy, do you say you have something else?
Yes, Mr.
All right, call your witness.
Could you please state and spell your full name for the record?
Elena Page Reimers, ALAINAREMERS.
Ms. Reimers, do you know Mr. Fenton?
I do.
How do you know him?
He's my mom's boyfriend.
Has he raised you at any point?
Yes.
Can you tell us a bit about that?
He's raised me since I was 12 and provided me with everything that I've needed.
Do you and him have a father-daughter relationship?
I would say so, yes.
What would you say about that experience as him acting like your father?
He's done more than what my actual father could have.
Alright, guys, buckle up, because this case wastes no time pulling you into controversy. In just seconds, the courtroom tension is fully ignited. A routine motion to set visitation suddenly turns serious. The mother raises alarming claims involving criminal history, CPS, and drugs. No evidence is presented yet, but the accusations alone shift the tone. This moment frames the father not just as a parent, but as a risk. The judge remains composed, signaling control amid emotional pressure. It is a sharp, suspenseful setup that hooks the viewer instantly.
You've never seen him have any kind of drug problems or
No,
any criminal activities?
no,
Okay. All right. You think, based on what you've seen, he'd have any problem raising a 3-year-old child?
no.
Okay. Those will be all my questions, Your Honor.
You have any questions for this witness? You have a seat, please. You testified about that, but to your knowledge, has Mr. Fenton ever dealt with an autistic child that's 3 years of age that's nonverbal?
No.
Thank you. You can step down. Any other witnesses, Mr. Murphy? All right. Do you have any other witnesses you wish to call? All right. This is a temporary hearing on a motion to establish some sort of visitation. The order that established Mr. Fenton's paternity of this child was entered by the child support magistrate on May 20th of 2024. And at that time, the order that was entered was entered based on the failure of the plaintiff to appear, which was Mrs. Hewitt. And nonetheless, it was entered that it would be a child.
All right, guys, now we move into the heart of the courtroom battle where everything unfolds. This is a full legal collision of emotion, testimony, and law. The father explains years of absence, denial, and his fight to be involved. The mother counters with fear, medical concerns, and personal history. Objections fly as hearsay meets hard legal standards. Witnesses reshape perception, and credibility becomes the real currency. The judge steadily cuts through emotion to focus on the child's best interest. In the end, the ruling balances protection with parental rights. It is a measured conclusion to a deeply human conflict.
There would be a establishment of paternity, and that he was found to be the father, that the primary residential parent would be the mother, and that the defendant, as the alternate residential parent, would have reasonable visitation privileges. So it has been established, and what is reasonable to one person is not always reasonable to the other, and that's one of the problems with reasonable visitation. The court finds that it is based upon the distance between these parties that it is reasonable for Mr. Fenton to have visitation at Mrs. Hewitt's or Miss Hewitt's home for a period of noon until 9 o'clock on every Saturday. Well, we'll make it one Saturday, and then alternate week will be Sunday. And that will continue for a period of 90 days. Following that, he will have visitation consisting of all day, and it will no longer be supervised. In other words, I'm going to graduate that to, it'll go from 8 o'clock in the morning until 8 o'clock or 6 o'clock that night, and it'll be day long, and he'll be allowed at that point to remove the child. After 90 days of every week having the child, visiting with the child, we'll assume that there is a problem, that there is no problem, and he'd be able to have the child and go that. That's all I'm going to do on a temporary basis. That will be continuing, and he'll have that child 1 week on Saturday, 1 week on Sunday, but he'll see it weekly because I'm trying to establish a bond between him and the child. This is a difficult situation because of the child's special needs. If you want to consult the CASA people to see whether or not they can assist you in that regard, but there's no evidence before me to indicate that there is any problem with Mr. Fenton as a father, and you can expect that barring something, this will gradually increase to become a lot more like a normal visitation situation. But a lot of that depends on whether or not Mr. Fenton is able to handle dealing with this young man, and whether or not the child adjusts to being away from you, and the special needs that he has are a question for the court. So I'm going to order this as a temporary basis, and then subject to review. If the parties can't work out an agreement, Mr. Murphy, you can revisit this motion.
Thank you, Ron.
And Ms. All right, thank you. And Ms. Hewitt, if you consult with the CASA people and they are able to give you some assistance, then, you know, we can this is a temporary order, which means it doesn't, you know, if the child has an adverse reaction, and again, I'm going to encourage you in order as a part of this, is that both parties will work to encourage the visitation being as smooth and beneficial to the child and not create an environment where the child is hesitant to go with his father. So it's, part of it's going to be your job is to try to make him comfortable with going to see his father. But if there is an issue, then it can always come back before the court, me or one of the other judges. All right, thank you.